evening, everyone. So today I'll be presenting on some updates from the Trademark Registry, a case on copyright, and also discuss the PDP bill withdrawal and the way ahead from it. So, can you move? Yeah. Yeah. So the first thing we'll be discussing is the trademark notice that we have. So on 1st of August, the Controller General of Patent Designs and Trademarks, Mumbai, had come up with a notice urging people to come up with settlements for their rectification and oppositions that are pending with the registry. So this is an urge from the registry to go ahead and dispose all pending oppositions and rectifications and report as soon as possible any amicable settlements that have happened. In cases where they have not been able to meet an amicable settlement and the cases have been pending with the registry has requested to opt for alternative mechanisms of dispute resolution and submit all and any possible related documents regarding settlement of these disputes through a link. So we have a link provided in the registry as well as in the notice, which is valid till 2nd of October. So we have a 3-month period to settle our disputes as soon as possible. So this has been done with a view to create a dispute-free IP regime. That is what the motive behind this is. So this comes as a celebration of the 75th Independence Day celebration, as we are celebrating the Amrit Mahotsav, Azadi Ka Amrit Mahotsav. So in that, it is an urge. So we are seeing this as an opportunity, a window of opportunity for us to settle and go ahead with trying to resolve issues regarding to opposition and rectification with our marks or clients. So in cases where there are oppositions which have been languishing on for decades, this is a very good opportunity to go ahead and settle them. And in cases, we see that there are some cases which are filed quite a long time ago. And those cases, the relevance or the grounds for opposition are no longer of any relevance to us. So we can go ahead and settle those. So, and then for that, methods for the alternate disputes are not necessarily required to be through an institutional mechanism. You can also have negotiations to clear through that. So moving on from this, we can go on to the data privacy law, which has been recently withdrawn. So we have the Personal Data Protection Bill. So since 2014, the government has been trying to come up with some regulation in regarding to the protection of personal data. So between 2011 to 2014, we have the Ministry of Personal Public Grievances and Pensions come up with a draft privacy bill regarding the same. But the final push for this bill came in 2018 with the judgment of the Supreme Court in case Puttusamy versus Union of India, where right to privacy was decided to be a fundamental right, and we have a right to be forgotten in that same. So moving from that, Sai Krishna committee was formed, and the committee in 2018 came up with a 176-page report regarding the requirement of a data protection policy and the bill, which was submitted to the Joint Parliamentary Committee in 2019 for recommendation. The committee submitted their report in 2021 December, and it has gone through a lot of consultation, revision, and commentary on that. This bill basically faced a lot of pushback from two sectors. First sector was the tech startup economy, and the other one was the civil liberties organization. So the tech startups believe that the measures given down in the data protection bill were very stringent, and it heavily criticized the data collection methods of these tech companies, specifically companies like Meta and Google. They were heavily against this. The other sector, the civil liberties organizations, they pushed back on the state overreach of the data protection bill. They believe that there's more that needed to be done to hold the authorities accountable for the kind of data that they would be having access to. So under the bill, the Data Protection Authority was supposed to be formed, and they would have uninterrupted, unrestricted access to the personal data of the public, and that required to be checked in the opinion of the civil liberties. So after years of revisions, consultation, recommendations, and deliberation, on 3rd of August 2022, IT Minister Ashwini Vaishnav decided to withdraw the bill. Now, the reason that he stated in the notice that was circulated was that there are a total of 81 amendments and 12 recommendations which have been taken into account that needs to be made in the data protection bill in order for that to be enforced. Now, which would require an entire rework of the bill and require extensive hard work on the people on the part of the draftsman to come up with something. So it was found prudent to come up with a new bill and introduce the bills which would cover a lot of a broader spectrum of activities in the online space and include separate laws on data privacy, overall internet ecosystem, cyber security, and utilization of personal data to amplify innovation in the country. So the bill is supposed to be presented as soon as the winter budget this year. So we're looking forward to the changes that are going to be made, and hopefully we'll come up with a good policy that would be a balanced one in terms of the protection of the people's personal data as well as the access by other personal data. So moving on from here, we'll go to the copyright updates. So this month, we have a case from the Tees Hazari Court. It is a case which is of relevance to us because it observes on the copyright protection of religious texts and the infringement of copyright in works emanating from the same author. So the case that we have is Islamic Book Service Private Limited versus Abdul Rauf Najib Pakali. The case was decided on 25th of July, 2022. So if we take a brief look at the facts of the case, the original literary work was authored by Maulvi Abdul Aziz. It was named Islami Talimat, and it came in 8 parts. It was written in Urdu. Now the plaintiff claims that they have the original manuscript as well as assignment of this original literary work, that is Islami Talimat, and they are the sole and exclusive owner of copyright through assignment in the work. In pursuance of that assignment, they have published the book in English and in 7 parts called Studies in Islam. And they have been exclusively and continuously publishing it since 1992 and have been advertising and publicizing it in Delhi and abroad as well. In 2018, the plaintiff claims they became aware of the defendant's business, also based on the author Maulvi Abdul Aziz's works, in the same name, nature, and style, called the Islamic Studies, published in English in 5 grades, grade 1 to 5. Now, the plaintiffs claim that they are the copyright owner over the book Studies in Islam, and there has been an infringement by the defendants, unauthorized publication of Islamic studies. Now, the defendant claimed that Studies in Islam is not an original work. It is based on the tenets and principles of Islam. In such cases, when we are deriving works from holy texts, it cannot be altered or substituted with any other thought, ideology, or principle. Hence, there will be similarities in the text. Moving on from the arguments, the court decided to favor the case towards the defendants, and the following case points were discussed. So, while determining whether there was infringement of copyrights or not in the published books, there was no clear transfer of ownership or assignment that could be established by the plaintiff in this case. Therefore, on the merits, only it was decided that there is no infringement and there is no locus standi on the part of the plaintiff to claim infringement on the copyrighted work. Secondly, the contention was that the deceptive similarity between the titles and the contents of the books published by the defendant and the plaintiff. Now, though it was held that there is no copyright on the titles, the title Studies in Islam and Islamic Studies pertain to a certain theme. And being the titles of the books, they are supposed to allude to the theme, and therefore there cannot be any copyright on the titles. Further, given the fact that there are various differences in the cover of the book, there cannot be any visual or artistic similarity even in that. Going on and moving on to the same similarity in themes and concepts, it was held that both the books have been originally authored by one person whose ideologies were interpretations from the holy texts of the Quran, of the Hadiths, and other religious texts. In such a scenario, there is no copyright over holy texts. As such, there is bound to be similarity in the interpretation that comes out of the contents of the holy text, and therefore no copyright can be claimed on it. Furthermore, determining on the copyright in the original literary works of an author, it was held that although there could not be a clear assignment established in this instance, in cases where an assignment is produced, even with the said assignment, an original author can write another book with different content on the same theme. That does not mean that there is an infringement in the works copied by others or adapted by others in the same work. So this case heavily relied on a previous precedent of R.G. Anand versus Deluxe Films. And on the basis of that, it was held that there cannot be any copyright on idea, subject matter, themes, plots, historic or legendary facts. In cases where similarity in any of these areas are contended, then violation should be confined only to the form, manner, arrangement, and expression of such an idea. Mere similarity based on fundamental and substantial aspects is not enough. There has to be fundamental and substantial similarities in the mode of expression. Same idea, when it is being developed from same source, there are similarities which are bound to happen. As such, judgment has to be made from the following test. The test is that of a reader who has read both the works must be under the unmistakable impression that there exists evidence of copying. Such evidence has to be clear and cogent, and it has to be based on material and broad dissimilarities. Moving on from this, we realize that in such scenarios, we have a clear precedent now that even, especially when it comes to same authors authoring two different books on the same theme, we have a judgment that says that even with similarity of content coming from the same author, there can be no infringement on two separate works, provided there are material and broad dissimilarities in that. So with that, I'll conclude my presentation. Thank you so much.